Okay, well, hello everybody, and welcome to the November edition of our a monthly legal webinar series. This month's presentation is called Stop Costly Mistakes, How to Safeguard Your Business. And we're going to be doing a bit of a general overview of all of the different areas of law that people running a business or business owners want to be thinking about, from business structuring to contracts, intellectual property, and more. Before we get into the legal content for today, for those that don't know who we are, we're Sprintlaw. I'm one of the founders of Sprintlaw. We're an online law firm made for startups and small businesses. Our mission is all about making legal services simple, accessible, affordable for those kinds of businesses. Unlike traditional lawyers, we don't charge by the hour, so all of our services are done on a fixed fee basis. We'll quote you up front and let you know what the cost is. We cover all the different areas of law, from business structuring, terms and conditions, intellectual property, leases, fundraising, employment law, pretty much any area you might need help with. We have lawyers that can assist. We also have a membership. It's optional, but about 90% of our clients sign up to it. It's got a full software platform with a bunch of tools, free legal documents, AI tools that you can ask for quick advice, a legal health monitoring system where we can help you stay on top of the things you might not know about. And we also have credits that we offer for our pro members that you can spend on getting lawyer advice throughout the year, as well as a helpline where you can book quick calls with our lawyers anytime. So check it out. There's a free tier for those that want to just go onto our website and see a little bit of what's included in that platform. We've been around for coming up to 10 years now. We are one of the fastest growing legal businesses in Asia Pacific. Have a bit of 8,000 clients and have won lots of awards. So we are pretty awesome. And if you are gripped by the urge to get some legal advice off the back of this presentation, do feel free to book in a call with our team or submit an inquiry through the website. We are doing a bunch of discounts at the moment for Black Friday. So if you move ahead with anything in the next couple of days, there'll be pretty good discounts on our fixed fee services and our membership and things like that. So it's a good time to get on top of it if you have legal to-dos. So what I'll be covering today is, as I said, a bit of an overview of all the different areas of law that you want to be across. We'll touch on business structures, what's the difference between sole trader and company structures, how to get set up, and what are the different models, and why you would choose one over the others for running your business. We'll touch a little bit on regulations. What might you need to comply with when you're running your business, whether it's in your industry or more broadly. We'll talk about contracts. What are the key kinds of contracts that you want to make sure you've got in place for your business? What do they do? Why do you need them? Intellectual property. What is intellectual property? What intellectual property do you want to be worrying about and protecting? Data and privacy. Again, what are the laws around that? There's been a bunch of changes in the last few years, and what might you need to do to make sure you're complying and keeping your customers' data safe? And then building a team. Again, what are the key legal documents and requirements? As I'm going through, do feel free to drop questions using the Zoom Q&A feature. I'll keep an eye on it. I might have a bit of time at the end, but I also really don't mind answering as I go if you've got a burning question on a topic that I'm talking about. So do feel free to ask. Before we get into all that, though, I just always like to talk a little bit about the more philosophical question for people running a business. When do you actually need to reach out and get legal help? It's not obvious in your business when you might need a lawyer. And bigger businesses do know when to use lawyers, how to use lawyers. They often have an in-house lawyer that can help tell them what it is that lawyers do and what they're for. But for smaller businesses, one of the big things we've seen at Sprintlaw where things go wrong is because small businesses weren't even aware that you could use a lawyer to solve a particular problem, or didn't realize the value of a lawyer in a particular task. And obviously you don't have much money to be spending on things like lawyers, and so it's easy to avoid investing in that stuff. But there's a really high failure rate for small businesses, and one of the key reasons is often due to preventable risks that could be managed with legal advice. So I think this is a good sort of classic risk framework for thinking about when you might need legal help for your business. Lawyers are principally used by small businesses as a risk management tool. We can help you put in place documentation. We can help you help you with compliance steps. We can help advise you on different situations to reduce your risk of something going wrong. A contract, for example, with your customers, if well written, can protect you from being sued by a customer if something goes wrong in your business. A contract with your employee can reduce the probability of employment law issues. A contract with your contractor can make sure that you're getting what you paid for and you don't get ripped off and that you own the work that they're delivering to you. And if you have these legal tools in place, the probability that something goes wrong goes down. Now, any small business owner that speaks to a lawyer, if they spend enough time asking them what kind of legal help do I need, they'd probably be overwhelmed because theoretically in any business there's tons and tons of legal tasks. You can write policies for pretty much anything. You can have contracts for pretty much anything. You can register trademarks for all kinds of things. You can have complicated company structures. There's all kinds of things you could do. But ultimately, if you're running a smaller business, you don't have the time, the budget, or the energy to be doing all that stuff. And so what you've got to decide as someone running a small business is, what am I going to spend my energy on? What risks am I going to focus on managing? And I think a good way of thinking about it is what we have on screen. Think about in your business, what are the big risks and which of those risks are very likely to happen? And while you have not much budget, focus on stuff in the top right corner of this picture, pretty big risk stuff that's reasonably likely to happen. As you get bigger and become a larger business, you start to cover off more of this square, and big businesses will have policies for even things that are like pretty unlikely and don't have massive impact. But as a smaller business, kind of start in the top right corner and work down as your budget grows. And so we'll talk in general terms in this presentation about what the big risk items are, but some of that is business specific. For a business that takes people hiking in the mountains as opposed to a business that provides online consulting, there are different kinds of risks and different kinds of documents that you might need. The person taking people into the mountains probably wants a personal injury waiver and those sorts of things, and that's what the severe risk is. Whereas a personal injury waiver is, if you're just an online consultant, not really that important. So it is a bit business specific in terms of what sits in where in this square, but you want to be thinking about that in your business. And things like shareholders agreements, business structure, customer agreements are typically top right corner stuff. Things like staff policies, social media policies, while you're small, might be more like bottom left corner stuff. But again, you should be thinking about that. So that's one way to think about where to spend your legal budget and where to spend your energy. The other aspect that is not that well understood by smaller businesses is that lawyers are actually really good at helping people make better deals and make better arrangements. And you can actually make more money or save money by investing in a good set of legal documents. For example, oftentimes when we're helping people with their customer agreements, maybe they've created a template that they use with their customers that they found online, or they've written up something themselves these days using ChatGPT. I've got my document in place, I'm all good to go. Lawyers know different models of how to structure these agreements that can actually really benefit your business. For example, we might be able to design payment clauses with late payment structures where if a client doesn't pay you on time, you could charge them interest in a way where it incentivizes you to get paid more, or make some extra returns if there is a delayed payment. And well-structured clauses like that can actually make a big difference on your operations. Similarly, referral partnerships, we can help design commission arrangements, or if you're working with suppliers, if you just sign what you're given, you can often end up paying more than you need to when a supplier doesn't deliver what they promised. And again, lawyers can help you design really tight scope clauses and those sorts of things that will make sure that if you're engaging someone for a costly project, if they don't deliver, you can either get a refund or some credits back, or they've got to rectify it for free rather than charging you more money. So again, important commercial arrangements, do consider getting legal advice. Certainly if you're raising funding from investors, that's an area where lawyers add a lot of value. It's not just about providing fine print that no one's going to read, if that makes sense. So that's a little bit of the overview to keep in the back of your minds, but let's talk some practical stuff. So one of the first steps that most people running a business will go through is deciding how to set up the business. You can either set up your business as a sole trader or individual running a business, or you can set up as a company. And there are a couple of other structures like partnerships and trusts, which I'll explain in a moment, kind of how they fit in. But this kind of distinction is one of the key distinctions that people make early on when they register their business. Now, you have to choose one of them. If you're operating any kind of commercial enterprise in Australia, it's required that you get some form of registration, an ABN number or an ACN number. So you need to pick one. You can't just go out and start selling stuff to people and collecting money. Otherwise, you'd be breaching the laws around that. So you need to pick a structure, but deciding the right one is a important decision. And it may be the case that you pick one and move to another one a little bit later on. So it's not a closed door decision, but there are pretty significant implications to the structure that you pick. So just to explain, when you set up a business as a sole trader, this is a very common structure for someone setting up a sort of one-person business. And if there's more than one person setting up a business, the equivalent structure would be called a partnership structure, which is similar to a sole trader, but just with multiple people. So when you pick a sole trader or partnership structure, it's one of the easiest ways to get set up and registered as a business. It's pretty much free. You can do it online yourself. You just sort of go onto the ABR website and kind of get registered, and you'll get your business number for your sole trader or partnership. And then now that you've got your number, you can go out and start doing business without too much hassle. So it's very cheap, very simple, very straightforward, and a lot of people choose to set up their business this way. The disadvantage of setting up your business as a sole trader and or partnership structure is if something goes wrong in your business, you, the person running the business, can be personally liable for the issues in the business. Unlike a company structure, which we'll talk about in a moment, there's no separation between you and the business. There's no separation between you and your personal assets, your house, your home, your musical instruments, whatever it is that you own. If something goes wrong with a customer in your sole trader or partnership business, they decide to sue you, they can sue you for all of your personal assets potentially. They can say, you've caused me loss and I'm suing you, the person, and I want a little bit of all that you own. So that can be quite risky because you're out there doing business, maybe you're trying some risky things, something goes wrong, your entire life can be on the line. And so we as lawyers don't love these structures. They are cheap, quick, easy, and often make sense for low risk small businesses or side hustles or those sorts of things. But for serious businesses or businesses with risk, we lawyers much prefer people to use this structure on the right, which is called a company structure. Company structure is a type of business registration that is designed to help separate your personal liability from the liability of stuff that you do in the business. And when you set up a company, what you're essentially doing is you're setting up a fictional legal person called the company. And that fictional legal person, the company, it will have its own name. It might have its own bank account. It is obviously not a person, but it has these people called shareholders who are kind of the body or the owner of this fictional legal person in the company, and then directors, which are sort of like the mind of this fictional legal person in the company. So these people can control that fictional legal person, but the people behind it are generally not liable. If something goes wrong with the customer can sue the company, which is its own person, but the shareholders and directors in general, who just kind of control this person, are not personally liable for what happens in the company. That's why it's called a limited company. And for most small businesses, they'll choose a structure called a proprietary limited company. So a private limited company. The liability is limited. That's what that word limited means. Now, there are exceptions if the directors commit fraud or do things that breach certain rules. But in most cases, the individuals behind the company are protected from risk. And so we as lawyers really like this structure because we are concerned, as I mentioned earlier, with helping people reduce their risk. And once you have a company structure, worst case, again, unless you commit fraud and those sorts of things, your company's assets will be on the line if you get sued or something goes wrong. But you as an individual, your house, your home, all these things, your end customers of your business can't come after that stuff. And so it helps you sleep a lot easier at night to run the company structure. There's other advantages. The company structure has different tax rates. It's easy to employ people. You can sell parts of the company to investors and other sorts of people. So it's a very flexible structure where when you're running as a sole trader or partnership, it's difficult to sell a piece of the business because the business is you. And so it becomes a lot more difficult to do things like that. Whereas with a company, it has owners called shareholders who, you can split the ownership of this fictional legal person between different people. So it is definitely got a lot of other advantages as well. But the principal one is about liability. We've got a question from Shanta saying, if a person earning less than 100, 200K, is it better to run a business in ABN or company? Look, that's a difficult question to answer because it's a lot of it is about risk, which I was just kind of explaining those differences. So the amount that you're earning is relevant. Obviously, if it costs more to run the company than you're making, it might make it difficult to justify having a company. But ultimately, it depends what your business does. If your business is doing a high risk activity, again, to use my earlier extreme example, if you're taking people hiking in dangerous mountains, then doesn't matter how much you're earning. I'd want to have a company from day one because if something happens, I want to make sure I'm not going to be liable for issues that might occur in those dangerous mountain routes. Even if you're not earning all that much money. If the activities that you're providing, you think about what's the worst thing that could possibly happen, what's the most amount of loss I could cause a customer, and it's not very high, then it may not be as urgent for you to switch to that company structure. The way I think about it is like, hopefully nothing will go wrong in your business, but the longer that you exist, the more customers you help, and in a sense, the more that you're earning, which is why that's relevant. It's just statistically, the more likely it is that you have that one freak incident where something goes catastrophically wrong and you're liable. If you've helped one or two people, maybe you'll get away with it, but once you've helped hundreds, things can go wrong. So the longer that you leave it without setting up the company, the riskier it is. But it's not really about the amount that you're earning. There can be tax differences where it makes more sense to have a company. The company tax rate is I think high 20%. As a sole trader, the income that comes in is treated just kind of like normal progressive income tax. So you have the sort of tax-free threshold where you don't pay any tax on the first 18 to 20K of income that comes in, whereas a company pays tax from the first dollar that comes in. So at small income levels, you may end up in a better tax position if you're a sole trader as opposed to a company, but then at higher income levels, you may end up in a better tax position as a company rather than an individual. So there are tax differences, and that's more an accounting kind of consideration. So, but as lawyers, we just think that the company structure is the lower risk structure. So when you can afford it, it is better. And Carlos has asked, can you set up a company structure? If you mean by you mean Sprintlaw? Absolutely, yeah. That is a lot of what we do. So that hopefully helps explain the company structure. Now, there are some more sophisticated structures that exist other than the single company structure. There are things called dual company structures and trust structures. In the interest of time, I won't go into these in great detail. I've done another presentation specifically on business structuring where I spend a lot of time talking about these, which I think is on YouTube somewhere. So if those of you that want to learn a bit more about this, you can check out that presentation. But just at a high level, setting up a single company structure is great already to help protect you from risk. But if your business starts to do well, your company actually starts to be quite valuable. In the case of me, for example, Sprintlaw as a company probably has much more valuable assets than I do as an individual. So I'm not only concerned about protecting my own assets from liability. You now start to become concerned about your company's assets. So as your business grows, you can set up multiple companies and get like double limited liability. So for example, in this model in the middle, we have a holding company and an operating company. The operating company is out there employing people, engaging customers, doing the risky stuff. But the business's key assets, maybe a lot of their cash, valuable intellectual property, or any other stock or assets that's owned by the business that's valuable, sit in a separate company called the holding company, which owns the operating company, which is then ultimately owned by the founders or any other people that set up the business. So in this case, something goes wrong with a customer, the customer can sue the operating company, but they can't get through to the holding company because this fictional legal person is owned by this fictional legal person, so they can only sue this company, and the key assets of the business will be protected. And you end up with these sort of two shields of protection for assets. So again, larger organizations often set this up, and if you set up in multiple countries, again for Sprintlaw, for example, we have Sprintlaw Group, we have Sprintlaw Australia, Sprintlaw UK, and we're looking at setting up other Sprintlaws. So if something goes wrong in our UK operating company, our holding company and our Australian company are separate, so they're safe from risk. So you can end up siloing your risk. So for larger businesses, this structure can make sense, but it can be obviously quite expensive to maintain two companies. And then we have trust structures as well, which can be set up as a way to hold your ownership stake in the company. You can see in these models, while the founders of this business are protected from risk from the end customers, they still may have a direct relationship with each other as individuals, because they'll be going into business together and to co-own this company. So oftentimes each of the founders of the business will add another company in between them and the other founders, and now they're very, very well protected because customers can't get to them through the operating and holding company, and even other shareholders can't come after their personal assets because they have their own company in the middle. The reason we usually trust companies is there are tax benefits to setting up things this way, as opposed to just having like another founder company, if that makes sense. But yeah, this structure you see on the right is a common structure for scaling businesses and larger businesses, where kind of best practice from a risk perspective, but also the most expensive because you need lots and lots of companies. But certainly at Sprintlaw, we have a structure like this, which we grew into over time. We began with a single company, evolved to a dual company, and eventually introduced the trusts once our revenue got into sort of the millions. So that gives you a bit of a sense as to how it might evolve for your business. So hopefully that makes sense on the business structuring piece. Once you got your business set up with the structure, maybe you're going with the sole trader for now. Ideally, you're looking at least a single company structure. The next legal thing to think about is regulations. Regulations are laws that would be passed usually by Parliament or by a government body, which anyone operating in a business that falls under the regulations needs to comply with. And the consequence of not complying with regulations is that you can be fined, and there can be other sorts of penalties for your business. And so you want to make sure that in the way that your business is operating, you are ticking the box of complying with regulations. Now, regulations, there are some regulations that are industry agnostic that apply to lots of businesses. For example, the Australian Privacy Act applies to lots of businesses regardless of industry. There's employment laws that apply regardless of industry. There's the Australian consumer laws that apply to lots and lots of businesses, the majority of businesses, which say things about when you can and can't refuse refunds and what you have to do. So there are industry agnostic regulations, but also in specific industries there are specific regulations. If you are working in childcare, for example, there's regulations around working with children checks. If you're selling products online, there's product safety requirements you need to comply with. If you're selling food, there's labeling requirements you have to comply with, and so on. So if you're selling alcohol, there's licenses that you need to make sure that you have. If you're selling food, in person at a premises, there's sort of, again, food safety things. So you want to make sure for your industry you are across what those regulations are, and you are getting the licenses or complying in the way that you set up your processes with what's required by regulations. Now, regulations aren't a thing where you go to a lawyer and say, tell me the regulations and make me compliant. Regulations are a thing I would encourage pretty much every person running a business to self-educate themselves on what the regulations are for your business and for your industry, and make sure that you comply with them in the way that you run your business, because usually regulations go directly to your business model and your business structure and your business processes. For example, labeling requirements on food products. There are requirements for you to put allergen information and ingredients on certain products. If you haven't figured that out in the way that you're manufacturing the products, you would be potentially breaching those regulations. So you need to figure out what you need to do and make sure it's part of your processes. Um, Financial regulations for those of you working in financial services or financial technology. Again, there's certain things that you can and can't say without a particular license. So again, you want to make sure that in the types of services or the advice that you're giving or the way that you market yourselves, you either have the license or if you don't, you're careful to not breach them. So there are usually industry bodies, either at a state or federal level, that provide free information on regulations for your industry. So I would encourage people to go figure out who the industry body is, check out their website. If there's anything you're unsure about, they usually have info packs or even a helpline you can call and just say, hey, I'm starting, a food business. What do I need to do? And they'll tell you what it is. You don't really need to spend a lot of money on legal advice for this stuff unless there's a very specific question you have. But definitely get on top of it because it can often be quite core to the way that your business operates. So we've got the business structures, we've figured out the regulations. Now we come to documentation. What are the key legal documents that you want to get in place for your business? We have this rather dramatic title, Contracts Are the Lifeblood of Your Business. And I think it is important to recognize the importance of these kinds of documents in the way that you operate. Again, people often think, oh, I just need to get some documents, download some templates, get the fine print in place so I look professional. That's not really what the purpose is of these documents. And I think, again, what I have on screen now is a good way of conceptualizing what contracts do and what documents you might need. So if you imagine your business as kind of that house in the middle, every business has relationships with different types of people. You'll have relationships with your customers. These are the people that buy your goods and services. You'll have relationships with your suppliers. Maybe they supply you products or goods. You'll have relationships with service providers, people for whom you're their customer. They'll do things for you. If you are, for example, an e-commerce business, your customers will be the people that buy your products on your website. Your suppliers will be the people that maybe supply you wholesale with those products. Your service providers might be your website designers, your website developers. With each of these people, you have different relationships. Now, again, if we look at it through the lens of risks with your customers, things can go wrong. Maybe they don't pay you on time. Maybe their payment bounces. Maybe you sell them something and something goes wrong and they have an issue or they complain about it. Contracts are there to dictate what happens in all of those different scenarios. Without contracts, it's very unclear what happens, and this can create frictions, risks, issues, and potentially serious liability for your business. If something goes wrong with a product you've sold to a customer or a service you've supplied your customer and there's no contract in place or no good contract in place, they could potentially sue your business for all of their losses. Now, a good contract will have in there, for example, a limitation of liability clause. And a simple, well-written paragraph in a customer contract which says something like, hey, if something goes wrong with the goods I provide you, if something goes wrong in the course of the services I provide you, you can sue me, but the most you can sue me for is a refund or 2 times a refund. You cannot sue me for every single little dollar that you've lost. And this can make a really big difference. To give you an example, we often help marketing businesses who control large digital marketing budgets for their customers. Maybe they get paid a few $1,000s a month for managing large budgets. If we had at least one case where we had a marketing agency who there was an issue with a Google Ads account they were managing. They were meant to spend $5,000 a month. They accidentally spent $50,000 a month because they added an extra zero. And it was 2 months, nearly $100,000 of customers' expenditure had been spent by accident due to an error. Now, the customer is obviously very angry and wants to sue the marketing agency for $100,000. The marketing agency is a small business, and a liability like that would put them out of business. They had a good customer agreement that said, you're only paying us a few $1,000s a month. We'll do our best to stay on top of the account, but the maximum we'll be liable for is, a refund of 6 months of our fees. But we're not going to be liable for hundreds of thousands of dollars in losses. You're not paying us enough to be liable for that, if that makes sense. And so in that case, the agency was obviously able to give the refunds, but it wasn't business ending for them because they had a good contract in place. So that gives you an example of how even a small business can have significant liability, but a good contract can sort of protect from that. So not just about liability, I mentioned earlier, payment clauses. What if the customer doesn't pay on time? Even just having in there a late payments clause, if you don't pay within 30 days of invoice, interest will be charged. You may not even have to enforce that late payment obligation, but having a clear contract, we see helps businesses run much more smoothly. Customers are more likely to pay on time if there's a deadline and a consequence. So again, tools like that, when well written, can make a real difference to your operations and really help secure your revenue streams and make sure that you get paid on time. So that's kind of the customer agreements. On the supplier side, it can be the inverse. Maybe you are paying a supplier or service provider to provide you with services, but they're late. They don't supply it on time. There's an issue with their services. There's an issue with their goods. Without a clear contract, they may start charging you more. Oh, that's out of scope, or well, sorry, too bad. I thought that product was fine. I disagree that there was an issue with it, and you're wasting time arguing with them, or sometimes out of pocket. A good contract that's been written properly can say, hey, if you don't provide goods on time, for every week that you're late, I'm going to get some money back. Or if you provide me with a service and there's an issue with it, for up to 6 months, you'll fix those issues free of charge. Things like that can really help ensure that you're not wasting money and you're getting what you paid for. And even having those rules in place often will lift the standard of what the supplier or the service provider provides you. So these are the sorts of things getting these things right can do. And I would encourage people to be aware of what you're signing. Don't just sign what you're given. Think about these kinds of issues. For critical agreements on the service provider or supplier side, consider getting them checked by a lawyer. Certainly for your customer agreement, which for most businesses you're going to be using again and again and again and again with your customers, consider getting that written properly by a lawyer. It's one of your most important documents. Not every business will be able to have a customer agreement. I mean, if you run like a cafe or a restaurant, you don't get people to sign a client agreement before they order their coffee. It's just not practical. And so, if they burn their lips on the coffee, you unfortunately may not have a liability waiver that you can use. But to the extent that you can put in a customer agreement, it is really a strong protection for your business for the reasons I mentioned. So definitely worth considering. We also have on screen partners, shareholders. These are other stakeholders that you may do business with. Maybe you have referral arrangements with people. It could be great to have contracts for that too, to specify what commissions you might pay, what the definition of a converted customer is, making sure you're not paying commissions for people you already knew, and how all of that stuff works. And then shareholders, we have that quite close to the house. These are the people that you may be going into business with, your co-founders or other business owners. Again, this contract is really, really important because if you go into business with somebody, and you don't document what happens in all the various scenarios of things that may happen, you can end up in a situation where there's a dispute that can be fatal to the business. And this is probably the number one reason we see businesses fail is due to a dispute between business partners. Now, sometimes that dispute is a big personal dispute that can't be resolved, but oftentimes it is simply because they didn't have a clear agreement in place specifying who did what people's responsibilities were, what would happen in various cases. And that leads to a blow up because there's different expectations where had the conversation happened at the beginning and it had been documented, then when the incident occurred, both parties would just be more likely to amicably agree to follow the rule book. And we see that happen again and again. So for example, if you go into business with someone, what happens if after a year, one person wants to leave and the other one wants to keep working on the business? Does that first person who leaves get to keep all of their stake in the business? If it was 50-50, one person works for a year, then leaves, the other one stays for the next 3-4 years. Is it fair that both of them get 50-50? Maybe it is, maybe it isn't, depends on what the business is. A shareholders agreement can help cover that. What happens if one person becomes too sick to work? Or what happens if one person wants to bring in a new business partner? Or all these different cases. What happens if one person wants to sell the business, the other one doesn't? What decisions can one person make without consulting the other, and what decisions have to be agreed jointly? All these details, you can see how it's good to agree a framework for them up front. And lawyers, of course, have tools on how this stuff should work. Once that's agreed, it can make the operations a lot smoother. And again, for those of you with business partners who don't have these agreements or have just maybe used a template somewhere and you don't really know what it says, I would really encourage you to get that document done properly because it's one of the usually top right corner high risk areas for most smaller businesses. So that's the contract stuff. Now let's talk a little bit about intellectual property. one of the other critical areas to be aware of as a smaller business. So when we're talking about intellectual property, what we mean is intangible assets of your business that may have value to them. And in law, there's many different types of intellectual property, but I have on screen the main ones that you should be aware of and you would want to consider protecting. One is trademarks and registered designs. Another is copyright. Another is confidential information or NDAs. Now, technically, in a legal sense, they're more contracts, not intellectual property, but I view them through this lens for a reason I'll explain in a moment. And then there's patents or patents, which are a protection for inventions. So I'll just go through each of them. First is the trademark. So a trademark is a registered intellectual property right that you can use to protect your business's brand name and its logo and a catchphrase, and there's a whole different bunch of types of trademarks, colors, smells, and those sorts of things. But the most common ones for businesses are the name and the logo if the logo doesn't look exactly like the name. Once you register a trademark for your name and or logo, you get the exclusive right to use that name and or logo in the country that you registered in the particular class, which is sort of like an industry that you've registered it in. That means no one else can use that name or logo or anything deceptively similar to it. So for example, for Sprintlaw, we've registered the word Sprintlaw as a trademark in class 41, I think it is, which is the legal class. We have Sprintlaw, the word, as a trademark, and we have that little S shape in our logo is a second trademark. That means that no one else in the legal space in Australia and the other countries that we've registered can use the word Sprintlaw or anything deceptively similar to it, Sprint Lawyer, Sprint Legal, Sprinter Law. No one could use that in the legal space without potentially infringing our trademark. We can send them a cease and desist if they try to it, nor can they use anything that looks like that S-shaped logo. So this is really important because if your business is going to invest a ton of money into its brand, building its brand reputation, getting its logo designed, putting all of your brand assets everywhere, and you don't own the trademark, A, someone else could come along, get the trademark and make it difficult for you to operate. You'll have to rebrand. Or B, there might be somebody already out there with a trademark. And while you're small, they haven't noticed you. But after a couple of years, your business starts to build a reputation. They say, hey, you've got to rebrand. You're infringing my trademark. And this happens remarkably often. People don't realize trademarks are not the same as business names. When you set up your business, you pick a name for it, but that doesn't give you a legal right to the brand. For example, Apple will have a trademark for MacBook or iMac or iPad. So that's not the name of the company, that's the name of its products, but you can't start a company called iPad that is then out there trading in the technology space. So they're different to the registered names. A lot of small business owners think they own the trademark because they registered their company or they registered their business. And it's true, you got to pay a fee and pick a name, and that name has to be unique when you register it. But that does not give you any intellectual property rights in the brand. If you haven't registered your brand specifically in Australia with IP Australia, which is a separate organization to ASIC where you set up your company, you need to do it. And this is kind of my personal mission to get all small business owners to get on top of their trademarks, because we realized in the first few years of setting up Sprintlaw that this was, along with the shareholders issues, this was one of the top really 3 reasons that businesses were failing. Is they'd be doing pretty well. Just as they start to do well, someone says, you're infringing my trademark. They end up in a long trademark dispute. They have to rebrand. They lose all their momentum, and eventually the business dies, or in some cases they suffer liability. So definitely get on top of your trademarks if you haven't. We've got designs. Designs are another registration done with IP Australia. They are a bit more specific to certain types of businesses, but basically it's possible for you to, on top of registering a trademark, if you're a product business, you can register the design of a product, so like a furniture or a bottle shape or some unique physical product design. There's also a registration for that, which again gives you the exclusive right to use that product design. And if people start copying that design, you can say you're infringing my design right. So again, if you're a product business, that may be relevant, but if not, it's usually just the trademark that you need. So a couple of questions in the chat. Question about the WH&S laws and the business structures I might come to that when I talk about employment in a couple of slides' time. So let me come back to Andrew's question. James has asked, what were the other big three reasons for businesses to fail other than failure of trademarks? I mean, it's, yeah, trademarks, the shareholders' issues, so business partners without a contract in place, and then it's the customer agreements, people using kind of templated customer agreements, and then that leading to all kinds of issues around inability to collect payments or liability. Those are kind of the big three that we've seen. So customer agreement, trademark registration, and shareholders agreement, I think are the things you want to get in place. Yeah. Now that's for businesses to fail. Also, the company structure is really important. That may not be the reason your business fails, but it may be the reason that you end up with a whole bunch of personal liability when the business fails. So maybe those are the big four: your company structure, your trademarks, your shareholders agreement, and your customer agreement. But equally, there's other important areas as well. So yes, bit of a tangent there, but a good question. So we've talked about the trademarks. The second form of intellectual property that you want to be across is your copyright. So copyright refers to any original works recorded in material form. And what that legal definition is really referring to is kind of original. We mean sort of creatively original. So written content, graphic design, audio. Copyright is obviously very big issue in the entertainment industry, for film and for music and for literature and novels. But in the business space, it can help protect your blog content or your business strategy, or if you're a technology business, software code is considered copyright protected. So this is the sort of stuff we're talking about. It's like original content of these various types: audio, visual, textual, and several others, recorded in material form. It can't just be in your head, but once it's written down, once it's recorded in some material form, which can be electronic, then it attracts copyright protection. Now, unlike trademarks, you don't need to go to the Copyright Association of Australia or whatever it is and register your copyright to get it protected. Copyright is owned by the author the minute it's created, and it's owned by them or their estate for 70 years after the death of the author. So the second you finish creating a creative work, you finish writing a book, or you finish creating a song, provided it's original and it's recorded in material form, you, the author, own that for a very long time. You don't need to go register it. It's yours. And if someone copies it, plagiarizes it, which is not a legal concept, but this is kind of the equivalent, then you can say you've infringed my copyright. You've copied my original work, and you needed to get my permission. So very important to be aware of copyright in business for a few reasons. One is you want to make sure your business owns its copyright. If you are paying people to write blogs for you, write content for you, do designs and graphics for you, record videos for you, any of that kind of stuff, you want to make sure that it's not theirs. If you don't get them to sign something in writing saying, I hereby agree to transfer everything I created for your business to you, that author still technically owns it. And you might say, oh no, but I paid them, it's mine. Just paying them is not enough under the Copyright Act. You not only need to pay them, or in fact, you don't even need to pay them. What it turns on is, have they signed a document in writing agreeing to transfer their copyright to you? If they have not signed that document, then in most cases, it's still theirs and they still own it. So we encourage pretty much every small business to have, if you're working with contractors, make sure you've got an intellectual property clause in your contractor agreement. If you're working with employees, of course, you want an IP clause in the employment agreement. There's a document called an IP assignment deed, which if you're thinking now, oh man, I've paid people and haven't got them to sign something, you can get them to sign a 2-page IP assignment deed that kind of works retrospectively, and make sure that you own everything they did. But making sure you've got these documents in place that anytime anyone, employees, contractors, any person creates stuff for your business, you own it, is really important, because again, otherwise you can be hit with a claim that you're infringing someone's copyright. So that's one aspect of copyright. The other area that comes up in business is, people are publishing their own blogs, or, you would, for your marketing, want to use photos, videos, music of other people. And doing so without permission can, of course, infringe their copyright. So it's very important to be careful with the content and that you use when you're writing stuff or using images on social media or otherwise, or music, that you got the rights to do so. There's plenty of royalty-free image sites out there which are specifically designed to say, hey, you can use this and you've got copyright rights to use it. So definitely use those if you're going to want to use free stuff or pay a little bit to make sure you've got the rights to things. Otherwise, you need to get the permission of the creators before you use their work. And same with your blog content or written content that you might write. Make sure that it's original, or if you're taking bits and pieces of various places, you're not taking so much that really you should be asking their permission. Or if you are taking a substantial part, you want to be getting their permission, or they could claim copyright infringement. And we do see this come up oftentimes now with a lot of automated AI tools. If you've got a blog out there using an image that you shouldn't be using, that you just got off Google Images, there are tools now that will automatically send you a message saying, you're using my image, you're breaching my copyright, you must pay me some money or I'm going to sue you, small business. And a lot of our clients receive messages like that, which can be pretty scary. So, and they do have a legal claim if you haven't got their permission. So just making sure that you're using that royalty-free stuff. And on top of that, I think is quite important in business. For NDAs now, as I said earlier, this isn't really intellectual property in the sense of you can own confidential information, but in business, what you want to make sure is that in addition to protecting your trademark and protecting your copyright, there are other things that you may have that don't qualify for trademark or copyright. Maybe they're business strategies, their models, their ideas, their secret opportunities that you have. They may not tick the box for copyright. Copyright requires this kind of original creative element, and it needs to be recorded in material form. If you've got a great idea for a business, that's not really copyright. It's often said by lawyers, there's no copyright in ideas because it's not in material form. But it's still maybe quite important to your business. You don't want people knowing, and it's got commercial value. So NDAs can be a really great way to protect that stuff that isn't quite copyright, but is still really important. And again, I recommend most businesses just have a simple NDA template. For those who don't have one, you can sign up to our free membership, and we've got, I think we include a couple of free documents, one of which is an NDA template that is at least a place to get started with an NDA. If people sign an NDA before you tell them information, they're usually bound to not tell anybody that information without your permission. And if they do so, they'd be breaching the NDA. So if you're speaking to, for example, a supplier about a product idea, or a developer, you want them to make an app for you, or an investor, or even just anyone who you're discussing a commercial arrangement with and you can be sharing sensitive information, getting them to sign an NDA is a great way to protect that information from disclosure. Now, it's not the case that people sue each other all the time for breach of NDA. It can be hard to find out if someone breached an NDA. So some people say, oh, NDAs are useless because you'll never know if they breached it. There is some truth to that, but there's been studies done on this topic showing that even the act of getting someone to sign an NDA changes behavior and makes it far less likely for someone to disclose your information, because people are worried about breaching a document they've signed. So the formality of it, I think, does have real value, and I do encourage people to consider using it before sharing confidential information. Finally, patents or patents. We won't talk about this very much. It's rarely relevant to small businesses unless you have come up with a pharmaceutical product or some kind of invention. People think it's relevant because they've heard the term, but patents or patents are for inventions that you may have created that are scientifically novel. They're pushing forward a human project. They've never been done before. They're not in any academic journals. It's never been written about, and you've come up with a new invention. Maybe it's the COVID vaccine or some kind of device or a computer software that's not just a normal app or something, but really, a new type of artificial intelligence that no one's ever created before. If you have a scientific discovery that may be productizable, then you can register a patent or patent, and you can get an exclusive right for 25 years to that invention. People have to pay you if they want to, sell it to anyone or use that technology or invention to sell it to everyone. For most small businesses, unless you are in a sort of high technology or high science space, it's not really relevant. In general, you're going to be focusing on those trademarks, the copyright, and the NDAs. But if it is relevant to you, there are patent attorneys out there that can really help you with that protection and explain to you a bit more about how that works. Um, so just a couple more slides. We're going to talk about data and privacy next. Another really important area to get across, and this area is a hot topic at the moment. Obviously, a couple of years ago, there were a lot of headlines about the Medibank and the Optus breaches that happened in Australia, and off the back of that, there were some changes to the Australian privacy laws. There's more changes expected in the next 12 months. As we do more and more business online, more and more information is shared online, and more information is used for digital marketing and other purposes. And we're obviously now in this AI era. Regulators' concerns around privacy are increasing, and my prediction is privacy stuff is just going to get more and more important for business owners to be across over time. Uh, uh, in Australia, we had some big changes in the last 12 months where the privacy regulators have been given much stronger enforcement powers, much stronger abilities to issue bigger fines to businesses. The privacy regulator was often, criticized in the past for not having the resources or funds to actually enforce privacy breaches. And so part of the regulation in the last 12 months was designed to address that. So for those of you who've been in business for a while and thought, oh yeah, I've never ever heard from the privacy regulator, the future may not resemble the past, and I'm expecting there to be a lot more enforcement in the future. So if you're not on top of privacy stuff, you want to get on top of it soon. Um, Now, in general, on the other hand, there is a big exemption for small businesses to make privacy compliance easy. If your business is doing under 3 million in revenue, then one of the key privacy laws, the Privacy Act, has an exemption for most businesses under 3 million in revenue. So if that's you, your privacy burden is lightened. Now, I should say there's exceptions to that if you collect health information or sensitive information, or you're collecting people's information to sell it. It doesn't matter how small you are, that exception doesn't apply. So it's not a blanket exception. Also, if your business starts under 3 million in revenue but then goes over it, if you weren't complying from day one, it could become very complicated. You've got to contact all of your customers and get them to sign things or agree to things. Um, and also, spam laws around email apply to all businesses. And also, that exemption might be abolished really in the next 18 months. So there is an exemption, but if you thought that that meant you didn't have to do anything, my view is I would act as if you have to do all the same stuff. Maybe the stakes are a little lower, but it's best practice to comply with the Privacy Act, even if you might fall under that exemption. So it's still relevant, everything I'm about to say. So in general, one of the tasks you need to do as a smaller business to comply with the privacy obligations, well, number one, you want to have a privacy policy in place. Usually you can put it on your website, but the privacy policy is a requirement of the privacy laws, and it fulfills a whole bunch of purposes. It also builds customer trust, and it works for the Spam Act. And what it says is, um, dear customer, when you provide me with your personal information, your name, your email address, your phone number, anything else I could use to identify you, when you provide me with personal information, here's what I'm going to do with it. That's what the policy says. I'm going to keep it. I'm going to use it to contact you. I'm going to share it with my team. I'm going to share it with contractors. It'll probably be in my IT systems. This is how it's going to be disclosed. Here's where you can contact me if you want to learn about what we're doing with it. And we take these steps to keep it safe. Basically, giving people transparency around how you're handling their personal information. That's one of the key requirements of the Privacy Act, and the privacy policy ticks a lot of the boxes of compliance. It needs to be accessible. It needs to be visible. People need to, you can't just have it buried in your terms and conditions. You need to surface it usually at the point where you collect people's personal information. So on your contact form, you got your name, the email, the phone number. You should say, by submitting this form, you agree to our privacy policy, or have a tick box, I agree to the privacy policy, so that when they give you the information, they know what they're giving you. If you collect people's personal information offline, like, you under running a wellness center or a medical clinic, you might have to have a printed version of your privacy statement there, or some easy way for them to see it when they provide you with that personal information. Because it is important for the Privacy Act that you're getting that consent when they provide you with that information. So that's the key requirement. Tell people what they're doing, which you can achieve through a privacy policy. In addition to that, there are laws around data breaches, where if something goes wrong with people's personal information, you get hacked as a ransomware attack, or for whatever reason, you're holding a bunch of customer information and it's leaked or breached. There are laws which require you to, A, take your best steps to limit the breach. And B, if it's a significant breach, report it to the OAIC, the privacy regulator. So these laws came out in 2018, 2019, so they're newish, and they are really important to be aware of. If you're running a business now and you suffer a data breach, you just want to make sure that you get legal advice and potentially cybersecurity advice as soon as possible after it happens, because there are these requirements that you do what you can to limit it, and tell the regulator and the people affected as well, if it's a substantial breach. Now, if it's a minor breach, you may not have to tell people. Someone accidentally forwards an email with a couple of people's email addresses to someone they shouldn't have, but the risk is all very low. The law is not that strict on minor breaches like that, but substantial breaches have all these legal requirements and fines attached if you don't comply. There is still an exception for those small businesses, which is why you don't hear that many stories of small businesses getting fined for mass data breaches. But again, I wouldn't be surprised if that requirement is abolished soon, and there are heaps of exceptions to that where it still applies to small businesses. So it's just best practice to be on top of this stuff. And investing in cybersecurity, which is not really a legal point, is also a really good idea now because of these legal consequences of a data breach. The best thing is if it doesn't happen to you at all. So that gives you a bit of a flavor for the data and privacy stuff. There are some laws in Europe called the GDPR, people may have heard of. If your business operates overseas and sells into different regions, there's multiple countries' privacy laws you may need to comply with, and they're a lot more harsh than in Australia. In the GDPR, you need cookie policies and very explicit consent. So get some specific advice if your business does operate internationally. But for Australia, the key things are that privacy policy and a bit of a plan for the data breaches. And for those of you that haven't had your privacy policy updated recently, there were a bunch of changes last year, so it's a good time to get it checked. Awesome. Now just onto the final slide. We've got our building a team slide, employment law stuff. To the extent that you are employing people or contracting people or getting interns, there is also a series of legal requirements that you want to be aware of. So if your business employs staff, of course, as I mentioned earlier, you want to have those employment contracts in place to make sure it's clear that you own the intellectual property and what they do. Employment contracts also help set out what people get paid, how sick leave works, how termination works, what the notice periods are, how probation works. People are familiar with these things, obviously, so we know what they do. They are not a legal requirement, but they're strongly recommended to do for legal compliance. But what the legal requirements are around employees are, there are a bunch of laws. There are industry agnostic laws about national minimum wages, the amount of sick leave and leave that have to be provided at minimum to permanent staff, and work health and safety obligations of employers. These apply across all industries, and then in specific industries, in most industries, there's another set of laws called the industry awards, and these, for specific industries, will set out minimum pay rates, overtime rates, and additional potentially rostering requirements and other requirements specific to that industry. So as an employer, you want to comply with the overarching laws, and also you need to comply with your industry-specific award requirements. And those are the kind of two areas of law. There's also tax things you have to comply with in terms of, paid-year withholding tax when you do pay runs, and if your payroll hits a certain level, there can be state-based taxes as well, and superannuation you have to pay. So there's additional, again, industry agnostic aspects there. So for those of you employing staff, the action really is to make sure you got an employment contract in place and make sure you're complying with all of those different minimum employer requirements, and also you're complying with those tax requirements. People often will use bookkeepers or accountants to help them manage payroll. If not, you want to get across that stuff yourself. So a few considerations when you're employing staff. We've got contractors. A lot of people get a bit overwhelmed by all the stuff I just said, having to manage tax and superannuation and payrolls and awards and all that kind of stuff, and often begin by using contractors instead of employees. Contracting staff is a lot simpler than employing staff. You can often just have one document called a contractor agreement, and you'll just pay an amount to a person. They've got their own ABN or business number or company. They'll handle their own tax, their own requirements, Like you generally don't have to pay them super, you just pay them the amount that they agree to. And so it could be a great way to engage people without all the admin. Usually you've got to pay contractors more as a result. And there are risks where if you really try and avoid employing someone by just having them as a long-term contractor and they only work for you and they're really kind of an employee in nature, they can become what's called a deemed employee. So that is a risk. If you're contracting someone, you've got to ensure they're a true contractor. Maybe they're not working with you permanently. Maybe they work for others. Maybe it's only for a period of time. But in general, it can be a lot simpler. And then finally, you've got your interns. This is a tool that a lot of smaller businesses use to get some sort of temporary staff without the commitment of having to employ them. Internships, the thing I always like to flag about these are smaller businesses often want to do unpaid internships because people are willing to work for free. Unpaid internships, there are laws about them because you're essentially breaching the minimum wage laws. It's allowed if it's what's called genuine work experience or it's for course credit for a approved tertiary course. If someone's getting credit for practical work experience at a TAFE or a university, it can be okay to do an unpaid internship. Or if it's what's called genuine work experience, i.e. they're genuinely getting more out of it than the business, which is a difficult threshold to prove, you cannot pay them. But unless it ticks one of those boxes, you actually have to pay the interns at least minimum wage. So be careful about the unpaid internships. Ideally, make sure it's for course credit. That's the safest way to do it. Otherwise, maybe get a bit of advice before you decide to do an unpaid internship because it could potentially attract fines and penalties. And we had a question from Andrew earlier I just want to touch on, which is work health and safety obligations and how that relates to business structures. Just on that, it doesn't particularly relate to business structures, but businesses are required to, by work health and safety laws, to maintain a safe workplace. The definition of safe will vary depending on what kind of workplace it is. A construction site, to tick that box, you may need to have some serious policies and procedures in place to ensure the workplace is safe. If you're a completely virtual online team, maybe it's more just about ergonomic chairs and things like that and giving people instructions on how to do it. It's a general duty. It's not super prescriptive as to what you have to do, but if you are found to be negligent or not provide a safe workplace in compliance with the laws, the employer can be fined or suffer liability to an injured employee. So worth considering, depending on what business you are, thinking about how can I make the workplace as safe as possible. You can get advice on that. You can get legal advice. You can get, if you're in a particular industry, there's compliance consultants. Or if you're a smaller business and the safety aspect is not super critical, you can just use sort of practical means to take steps. But if you do nothing, there's a high chance that you could be found to be negligent or in breaching of those laws. So it is worth turning your minds to. And yeah, of course, it's a good question around compliance and certainly workplace. And one question we have from Carlos: how much to set up a company? ASIC charges a little under, I think, $500, or maybe it's more now actually, somewhere between $500 to $600 to set up a company. Legal fees on top of that if you get help with it. I mean, Sprintlaw, I think, charges around $1,000 to register a company, including the ASIC fees. So yeah, you're looking at about $1,000 or a little cheaper if you want to do it yourself. So that comes to the end of the presentation. If there are any more questions, I know we're a bit over time. I will stick around for a minute and see. But otherwise, thank you all for attending. I hope you found this useful. As I mentioned, if there's any legal help you need off the back of this, do reach out to our team. And it's a good time in the next few days, given that we're doing these Black Friday discounts for new clients and existing clients. So do feel free to reach out. Otherwise, we do these each month, so do feel free to sign up to the next one and come along. So yes, thank you all so much for attending. And yeah, it doesn't look like there's any more questions. So, oh, we got one. Is work cover a must if it's only you as an employee? I'd encourage you to go to the work cover website because they have a tool that helps you work out how work cover works. I think it depends on the amount of income and your business structure and a couple of other things. And in some cases, you may not need work cover if it's a very small scale operation. but they have usually a free tool on their site, and you can also call them if you're confused at all. So definitely check that directly with them. But usually, once you hit a certain amount of wages paid, you need to get work cover, and it's a mandatory insurance. Yeah. Cool. Doesn't look like there's any other questions. So thank you all so much, and all the best. I'll see you next month.